To my computer. All right. Great. Good evening, everybody. Um, this is the Concord subgroup of the Metrolina Real Estate Investors Association monthly meeting for February. We have two fantastic guests today. We have Brien Brandenburg. And Brien, I don't have my bio of you in front of me right now. I'm a little disconcerted. So if you would give your bio, if you don't mind. And the same thing, Kelly, I had it all planned. I don't have your bio right now. So if you guys want to introduce yourselves to our group.
Ladies first.
All right, thank you. My name's Kelly Jenson. I'm an attorney. The name of my law firm is Jenson and Rains PLLC. We're in Charlotte, North Carolina. We practice estate planning, probate, business, and construction law. My husband and I started the firm 6 years ago. And yeah, we've just been growing. We have another attorney. We have two support staff. We moved into new office space last year, and just enjoying forming new businesses and helping businesses get off the ground, and people do estate planning. So they're protecting their assets, planning for the future, making sure they're not leaving a mess behind for their family. And yeah, just enjoying that. I'm happy to be here. I'm talking tonight about the importance of utilizing LLCs and living trusts for asset protection and estate planning purposes.
Thank you. And Brien?
Thank you very much. I appreciate the opportunity to address everyone. Good evening, everyone. My name is Brien Brandenburg. I work for Mutual of Omaha Mortgage. I specialize in the reverse mortgage and the HECM program. I've done that since June of 1998. I've probably got more experience than anyone else here in the great state of North Carolina in the HECM program. I've originated them and worked exclusively in that business for 22 years. So I help people leverage their home equity, either through a reverse mortgage to improve their financial situation, or to use the program to purchase a new home. I live in Greensboro, North Carolina. I'm married with two lovely daughters, one who goes to college at Appalachian State, the other one's still in high school at Grimsley High School, Weaver Education Center. I graduated myself from Grimsley High School, spent 7 years in the Marine Corps after I graduated from high school, and somehow got lucky and found my way into the mortgage business, where I have been privileged enough to work for several outstanding companies and work to help seniors enjoy a better quality of life by looking to home equity as one of the tools in the big toolbox of how to plan for retirement. So I thank you for giving me the opportunity to speak here tonight. It's great to meet everybody, and I hope I can offer some information that you may or may not have known before.
Excellent. I appreciate you both. We ended last month's presentation with another phenomenal HECM professional, and also a certified financial planner. And we ended it talking about some of the advanced strategies for investors, use of HECM. And I think it might be good to, for continuity's sake, to start with where we kind of left off before. A lot of people, and I think everybody here was there before, a lot of people, they have a misconception about HECM for purchase or reverse mortgage. They think it's they don't, a lot of people don't know the updates and changes that were made, especially when FHA stepped in with their insurance of it. And they think that It might be people that need the reverse mortgage, might be people that don't have enough money to live on in their monthly budget. So it is good for that, and we do understand that it will be um, a lifestyle change and freedom for people who don't have quite enough income to make it. So not having to pay a mortgage would be a leverage and a freedom for them. Many of our investors, though, have those bases covered. They may not have a mortgage. If they do have them, because we're real estate investors. So if we do have a mortgage, it's, pretty much well planned. And I understand that there's some advanced strategies that HECM can be used for and reverse mortgage can be used for in terms of creating tax-free income or Brien, I'll go to you first and tell us some of the advanced strategies that some of your more solid in terms of wealth investors have used HECM for, or reverse mortgages in HECM for.
Sure. So when the reverse mortgage, or HECM, which stands for Home Equity Conversion Mortgage, when the plan and the program first came out, it was signed into law back in 1987 by President Reagan. And it was a demonstration program through HUD that allowed for 50 lenders to do 50 loans to see if it was something that people would embrace or like. And back then it was created with the idea of seniors who want to age in place and may have difficulty in meeting their financial obligations can tap in and leverage their home equity to create a better outcome for their retirement. And that's how it was really basically used for the first 10 or 15 years that it was available. There weren't all of the protections that they have today. There's been many changes that have been made in order to protect those people who choose to take advantage of the reverse mortgage program. And so a lot of those things have protected non-borrowing spouses. It has ensured that somebody can't get foreclosed upon simply because the home is less in value than what is owed. So a lot of different changes have been made. But for investors and people that are looking at their own home equity, the biggest use I see of it today is for those people who are living off of a retirement income and they're concerned that during a potential stock market downturn that they wouldn't be able to maintain the same lifestyle that they've become accustomed to. So, many people that are seniors, they've got certain investments and other things that return a certain income every month. And if that income doesn't come in, then they have to either change their lifestyle or they have to, I'm sorry about somebody in my family's printing something. Or they have to consider taking principal investments out of their portfolio that's outside of what their plan already had. And so if you begin to take principal investments from your portfolio that were unplanned due to unexpected expense, due to a stock market downturn or something of that nature, then you've taken away from those investments that can return your income later. And so the income that you were expecting is going to be less. And so what can you do for unexpected expenses? What can you do for an unexpected stock market downturn, especially if it happens early in retirement? And that's something that's called sequence of returns risk. So if you're somebody that retires and early in your retirement, the stock market is performing very, very well, then your sequence of returns is positive and you're not worried as much because the money coming in and the growth in your portfolio will be enough to survive for a life expectancy, which is more and more becoming longer and longer. So there's several things that we just don't know. Longevity, how long are we going to live? What are the returns on my investments and things like that? And so one of the things that people have turned to is the use of home equity for those unexpected expenses or for those negative sequence of returns. So if you retire and then early in your retirement, the stock market underperforms and you need to have a certain lifestyle that you expect or a certain return, well, what do? Well, your financial advisor could say, well, you're going to have to learn how to live off of less. Well, if you're somebody that just retired and you've had these big plans, what do you mean I have to live off of less? What do you mean I have to decide that for the next couple of years until the stock market begins to perform again and my portfolio can rebound from the losses, that I can start taking the trips that I had planned or living the life that I had planned? So, everybody remembers what happened in March when COVID came in and everybody got scared and many people in the stock market began to sell. And what happens when everybody's selling and not as many people are buying? We see the stock market go down. And so for those people who were too much invested in equities or other type of strategies, they might have seen their income go down. So what were they to do? The savvy investor who had potentially foreseen such a outcome may have set up a reverse mortgage early in retirement so that when those negative sequence of returns occurred, they could draw from home equity instead of from the portfolio. And so they could supplement their monthly income with home equity withdrawals until such time as the portfolio rebounded. And as everybody knows, as the year went on, while 2020 was difficult, we did see the stock market come back once sanity returned. And so when the stock market begins to give positive returns and our portfolio is beginning to overperform, then we could pay down those draws that we took instead. So there was a study done by Dr. Barry Sachs that looked at this concern of early negative sequence of returns risk. And he compared the idea of, all right, let's set up a reverse mortgage early in retirement so that we can pull from home equity in those bad years, replenish in good years, compared to, well, what if we didn't do it and we waited and did that as a last resort? And we used our portfolio to live and then we only tapped into home equity at the very end. And the difference was amazing in that he saw that during a 30-year period, he chose from 73 to 03. And he chose those years because there was negative returns early in that retirement window. And he saw that there was an over $900,000 difference in that person's ability to live. And so if they did the loan of last resort after they had exhausted their portfolio and all their investments, they ended up running out of money before they ran out of life, and they left nothing for their heirs. Whereas those people that would have set up the reverse mortgage early in retirement and would have drawn from home equity in the negative years, as opposed to drawing from principal investments, when they died after 30 years, they actually left an almost $400,000 portfolio to their heirs. And so the question becomes, if you're going to retire and you have these investments, you have home equity, what would you rather leave to your kids? Would you rather leave nothing or would you rather leave something? And I'm sure everybody would agree, you'd rather leave something if possible. So that's just one area of use. The other thing that we're seeing people is when they're looking to buy that last home. We know all about first-time home buyers, but I work with the last-time home buyer. So imagine you have a client or you're an investor and you've lived in that house where you raised your kids, and it's your beautiful 3,000 square foot house, 2-story brick, and you got the big yard and all that other good stuff. And then here you are at age 65 or 70 and you say, I'm ready to retire. And I don't like those steps. My master bedroom's on the 2nd floor. And, this yard work, no thank you anymore. The leaves, I got to cut the grass. And if it snows, I got to shovel this. I've got all these outside things I have to do to maintain my home. Well, who wants to do that when you're 70 years old in retirement? And so oftentimes these people choose to sell that home that they raised their family in, and they want to take those proceeds and purchase a retirement home. And oftentimes they're looking at 55 plus communities where all the outside maintenance is done for them. It's one level living. There's no steps. There's no stairs. It's accommodatable to people that happen to be in wheelchairs. You can get in and out of the bathroom that way. And you have like-minded individuals in the neighborhood. So those people are looking to buy these homes, and they oftentimes could pay cash for the home if they wanted to. But what the HECM provides is an option that they may not have had before. And you can say to that person, well, let's say you sell that house for $400,000 and you want to buy one of these 55 plus communities, which there's a bunch of them right there in Charlotte. You could go in and you could buy one of those brand new homes with no maintenance, you know, furnished exactly as you want, and you could pay cash for it. Or maybe you could look at the HECM program where you would only have to put half of that amount down and you could keep the other half in your pocket. What could it do for your investments if you bought that $400,000 retirement home and you only had to put $200,000 into it? And you could take the other $200,000 and you could invest in investment property, a second home, condo at the beach. You could buy that RV you've always wanted. You could travel. You could help your kids or grandkids. And so it gives you opportunities and choices that you may not have had before. And so I talk to people all the time about this, and I say, what if you knew you could double your purchasing power? And instead of buying the home that you think you want to pay cash for because that's all the money you have, what if I told you you could buy something that's exactly what you want, with all the amenities that you want, with the upgrades that you want, with all the things that you want that's brand new? So there's no maintenance, there's no repairs, there's none of that to worry about. There's no yard work, and there's none of these things. And then you can also put some of your hard-earned money that you are going to get from the sale of your departure residence into investments or into savings or into cash flow for retirement. You know, a good financial advisor, if they can get you 5% per year on $200,000, that's over $800 a month in additional cash flow. And everybody knows that in retirement, cash is king. So if we're talking to people that are going into retirement and you tell them that you can improve their cash flow, they don't have to take on the obligation of a monthly mortgage payment, and they can buy that dream home for that last home, it just becomes an attractive option to them. So, you know, there's qualifications based upon your credit and income, just like everything else, but it's not based upon credit scores. You don't have to use a income base to show you can make a monthly mortgage payment because there's no payment. You just have to show you have enough income to pay your property taxes, homeowners insurance, and have enough money to pay the bills and buy food. So it's become a very attractive option for the affluent and those who are looking to leverage the money from the sale of their departure home. I did one late last year for a guy who's a millionaire. He could have bought his house 10 times over for cash. He was worth millions of dollars. And I said, well, you know, why are you choosing to use the HECM to buy this house instead of just paying cash? He said, Brien, I want to take that money that I'm not putting into paying for cash, and I'm going to invest it. And I'm going to grow my savings. It's going to help create a better legacy for my kids and grandkids when I'm no longer here. And I can use that money to spend on them while I'm still here. So I can take them on a trip. I can take them to Disneyland. I can go to the Virgin Islands. I can do things with my family while I'm still alive and give my legacy with a warm hand rather than wait until I'm dead and gone and I pass all my onto my family with a cold, dead hand. And I was blown away when he said it that way to me. So I asked, what would you rather do? Would you rather spend your time and effort and money on your family while you're here to build memories? Or would you rather build a legacy of a home that's paid for that you're going to leave to your kids that they're probably just going to sell and put that money into their retirement? So which would you rather have? And more oftentimes than not, when they look at their options, they'd rather spend that money today on lifestyle and improving themselves and enjoying, you know, knocking some stuff off that bucket list that they otherwise may not have had the ability to do had they paid cash for the house, or much less take out a regular mortgage, and then you've got a mortgage payment in retirement, which nobody wants. So those are just a couple of the ideas of what people have done with it.
Okay, I think those are wonderful ideas and great additions. Last month we had the financial advisor had an idea that said if, let's say a person has their money in a 401k and, there's a penalty and taxation for taking it out early. Oh, wait, we got someone else in the waiting room. Here he is. So the idea was that they could take the money out of their 401k and use a reverse mortgage to pay the taxes, and then put the money from the 401k into a Roth, create a Roth, and then it would grow tax-free. And
Yeah.
I'm not sure which of you guys would be the best to answer that.
Well, so the idea of using home equity to pay the taxes on a Roth conversion. So you would be converting from a traditional IRA to a Roth IRA, or from a traditional 401k to a Roth 401k. So, there's certain limits. If you make over a certain amount of money per year, you cannot contribute to a Roth IRA. So if you wanted to do that conversion, one of the things you need to look at is, if I do it, where do I bump up against the next tax bracket? So I believe this year, there's a tax bracket that stops at about 172,000. So you can convert every year right now between age 65 and 72, you can convert $20,000 per year from a traditional IRA to a Roth IRA with no taxes and no penalties. But that's per year. So over the course of 5 years, you can put $100,000 into a Roth, which then becomes non-taxable when you take it out at a later date. If you want to do more than that, then of course, if you have it in a traditional IRA or a 401k, then those have been tax deferred. And so you're going to pay whatever that tax level is based upon your current income this year. So there has to be a happy marriage where you're not going to pay all those taxes and convert it into a Roth if it doesn't make a lot of sense, and especially if it puts you into that next higher tax bracket. So that's a situation where the financial advisor really needs to be the one that's involved with taking a look at it in conjunction with your CPA. If that financial advisor is not quite savvy enough on tax law, usually they are. Usually they know exactly what the taxes are, because that's a big part of their planning, and they have a CPA on staff in their firm. So using the proceeds from a reverse mortgage to pay those taxes, and you wouldn't pay a penalty if you're over 59 and a half, you don't pay the 10%. That would need to be a conversation with everybody in the room involved to take a look at all the numbers to see if it makes sense or not. If not using home equity to do that through a reverse mortgage, do you have other assets that you could pay those taxes with rather than take it from home equity? Because if you take it from a home equity, interest is going to begin to accumulate. Whereas if you're just liquidating an asset, there's no interest accruing against that. That may be the better option on a Roth conversion. You just have to take a look at all those different situations.
And Adamma, I have something to add there. So I'm like Brien said, I'm not a financial advisor. I'm also not a CPA. So, the analysis of whether that's the best use of your money or the best use of a reverse mortgage, I can't do that. But I can tell you that generally people are doing more Roth conversions now for a couple of reasons. One is everybody is assuming that taxes are going to go up in the future. And for your tax deferred retirement accounts, guess what? You got to pay tax on it when you take that money out. The other thing is last year, actually, it's been, a year and 2 months now, Congress passed the Secure Act. And what that did is it changed the way that your heirs inherit these tax deferred retirement accounts. So back 3 years ago, what you could do is you could leave someone, you could leave a family member, a child or a grandchild, a really large 401k or traditional IRA and as an inheritance, and they could take their whole lifespan to take that money out. And so they could stretch out all of those taxes, because when they take the money out, they have to pay tax on it. So they could stretch it out over their whole life cycle and slowly take the money. They can't do that anymore. It's either over the period of 5 or 10 years now. That law is gone. I mean, it's a dramatic change in the way that tax deferred accounts are inherited. And so for some people who can afford to do the conversions now, they're looking at that as something, well, you know, if taxes are going to go up and my heirs are going to have to pay higher taxes on it when I leave it to them, maybe we can pay tax on it now while tax rates are lower and use that money for other reasons. So, you know, whether or not using the reverse mortgage is a good idea, I can't answer that. And it's going to all be completely specific. But I did want to mention that to you guys while we're on the call, that there are a lot of people who are looking into creative ways to do those Roth conversions.
Great
Excellent.
point.
Excellent. Excellent. Okay. And does anyone have any questions for Brien or for Kelly just thus far?
I do. Can you hear me? This is Richard.
Hi, Richard.
Hello, Adamma. He was saying that you can do $20,000 a year from your traditional IRA or traditional 401k into a Roth format, whether it be a 401k Roth or a IRA Roth, with no tax penalties.
Yeah, from age 65 on, currently, according to today's law, you can do a conversion from your traditional IRA to a Roth at $20,000 per year without having to pay those taxes. So if you have that money in an IRA today, you can switch it over. So over the course of 5 years, you'd be able to move $100,000, and that's a lot of money. And again, these laws can change from year to year.
They can take them away, yes.
Yeah, but currently that's what it says. They'll let you move $20,000 a year.
Right. So then you'd really only, let's say you had 300,000 in there, you could only get, depending on your time span, 20,000 per year until you reached, 72 and a half now, that before you have to do RMDs or mandatory pullouts.
Yeah, and I could be wrong, but I believe the RMDs only apply to traditional. They do not apply to Roth.
Right, but what I'm saying is, though, you take whatever age you are now, by the time, if you can't get it all out at 20,000 per increments, then you'd be paying tax on the remainder to convert that. But once it's converted over into the Roth, you don't have to do the RMD, if I'm understanding correctly.
Yes, sir. That's the way I understand it as well.
So, because my time horizon is, I'm already pushing up to about 3 or 4 years before, maybe 5 before I would reach that. They increased it. Is it 72 and a half now? It used to be 70 and a half.
Yeah, we probably need a good CPA on the call to answer those questions.
Okay.
I'm a reverse mortgage and HECM expert, not a tax expert.
Okay, I didn't catch what and I couldn't read your deal on your shirt.
Yeah, Mutual of Omaha Mortgage.
Okay.
Yeah, Robert, it's 70. I think it's just 72. It's either 72 or 72 and a half, but I think it's 72. I think it went from 70 and a half to 72. Okay. But that might be wrong.
Right. Yeah, I understand.
Mm-hmm. And go ahead.
Yes, with the reverse mortgages, how can you sort of back into what you would maximize on that? And what about the fees compared to a traditional mortgage?
Yeah, so with a reverse mortgage, people typically qualify for almost or about half of what their home is worth. The younger you are, the more, the less you qualify for. The older you are, the more. So a 62-year-old would qualify for probably about 48% of what their house is worth in terms of cash. whereas a person 95 or above would qualify for almost 75%. And simply it's because, they know that, the older you are, the sooner you're going to pay it back. A 95-year-old is not going to be around quite as long as a 62-year-old.
Mhm.
The fees can all be financed into the loan, and the fees are not cheap. Some people say that a reverse mortgage is expensive, and my question would be, compared to what? What other loan can you find on the planet where immediately after taking it out, are you not required to begin to make monthly payments to repay it? So with a reverse mortgage, one of the biggest upfront costs is the mortgage insurance that's paid to HUD. And HUD requires that for anybody and everybody choosing to use the HECM program. So all that money is pooled together into an insurance fund. That insurance fund guarantees several different things to the reverse mortgage borrower. Number one, you're guaranteed never to lose title to your home. Second, if you set up a line of credit, you're guaranteed that it can never be canceled. It can never be called due and payable. It can never be reduced. Third, if you take out a monthly payment where you're receiving income from it, it can never be stopped. And probably the biggest benefit that mortgage insurance guarantees is that you can never pass a debt on to your heirs. If you choose to do a reverse mortgage and you exhaust all the funds, and you live a long time and your home never goes up in value, or God forbid goes down in value, and at the time that you move out, sell, or die, the home is underwater and more is owed on it than could be made through the sale, then you can walk away free and clear. If you die and leave it to your heirs, if the home cannot be sold for as much as owed, your heirs can turn the keys in and walk away and they owe nothing. So they can't attach any of your other assets. So that insurance guarantees to the lender that they won't lose any money. And it guarantees to the borrower that you can never leave a debt to your heirs if you exhaust all of your equity when you take out the reverse mortgage.
Okay, I follow that. There's a cap on the amount that the home can value out at.
Yes, sir. This year, the cap changed and it went up to $822,375. So they will lend you a portion of that. And again, if you're 62, it's about 48%. If you are 95 or above, they'll lend you 75%. If your home is worth more than the $822,375, anything above that is not considered in the calculation. It's not part of the deal. Now, they do have jumbo reverse mortgages, and they are available in North Carolina today, but those are different in that the interest rates tend to be higher. Today in North Carolina, it only allows for a lump sum distribution. You can't set up monthly checks or a line of credit. And so, typically the person looking to do those are $1 million plus homes, and they're just looking to exhaust the monthly mortgage payment. But there are jumbo, proprietary products that are available still.
Okay, what if, for an example, let's say a male is 64 years old, but his wife is, say, 56. It's based on her age. Would he even get anything?
So today you can still get the reverse mortgage if one of the spouses is under 62. But it can only be done if you're spouses. It can't be done if you're brother and sister or, two best friends.
Right.
It's based upon the age of that younger borrower. And so that person becomes what's called a non-borrowing spouse. But if they live in the home, it's called an eligible non-borrowing spouse. And the big change that happened several years ago was if somebody signed off on the home's title and became the non-borrowing spouse, if that older spouse died, then the loan had to be repaid. And that younger spouse had to come up with a way to repay it or refinance it. Today, that non-borrowing spouse enters what's called a deferral period, and they do not have to pay back the loan. They can stay there forever and ever and ever, and it's not due and payable until that non-borrowing spouse moves out, sells, or dies. But the amount that they will lend is based upon that non-borrowing spouse's age. So somebody that's only 56, they're probably only going to lend you about 40% of what the house is worth, and not, 50 or 52 or what have you.
And that was more than I thought they might, being at that age difference. Then the last question, let's say that someone's just looking, say, like for 5 years to not have to make any payments, and then you'd like to bring it to paid off status. How does that play in with what you would do for a traditional mortgage, fees and interest rates and that sort of thing?
Sure. So when Congress passed laws back in after the 2008, 2009 crash, one of the things that they changed was that there can be no prepayment penalties on any mortgage for your primary residence. So all HECMs are done on primary residence. They cannot be done on a second home, vacation home, or anything like that. So if you were to do one of these and 5 years later you decided you wanted to pay it off, you would simply pay off what you borrowed plus the interest that had accrued upon the loan, and then you would then own the home free and clear. There are no prepayment penalties. You can pay as much as you want. You can pay as little as you want. You can pay as often as you want or as infrequently as you want. There's no required monthly mortgage payments or any payments at all. The only thing that you have to do is you have to live there. It has to be your primary residence. You must pay the property taxes, homeowners insurance, and if you have them, HOA dues.
Okay, but the question that I was asking though is how does it compare to a traditional mortgage if you did it in that example? Or, I mean, I don't know what the interest rates are. I've not heard them being battered about. Are they at 6%, more than that? Is there a way to ferret that out?
I'm sorry, I apologize for not addressing the question that you specifically asked. So
that's okay.
Just like regular mortgages, there are both fixed rate loans and there's adjustable rate loans. Today at Mutual of Omaha, our adjustable rate loans start at 2.6% and our fixed rate loan starts at 3.8%. And so if you never make a mortgage payment, then 5 years from now, the money you borrowed plus that interest is going to be a lot more than what you borrowed. If you're taking a regular 30-year fixed rate mortgage or something of that nature, you're going to be making payments, which will pay that interest and it'll pay some of the principal as well. But as you probably all know, on a 30-year mortgage, your first few payments, it's mostly interest. So, if you buy a house and you make mortgage payments for 30 years, you've almost paid double what that house costs. With a reverse mortgage or a reverse mortgage for purchase, you put down about half. If you never make monthly mortgage payments, all you've ever paid is half. So the balance will grow and you will owe more than what you start with if you never make a payment. But the interest rates tend to be a little bit higher than a traditional mortgage. Today, I'm in the middle of, believe it or not, of refinancing my own mortgage, and I got a 10-year at 2 3/8. I believe a 30-year fixed rate loan is probably 2 3/4. And as you probably know, mortgage rates change every day, sometimes multiple times a day. Did that answer your question?
Yes, thank you for taking the time and answering. Yes, it does. It gave me a parameter. I was thinking they might be at quite a bit more interest rate than 3 point something, which isn't too bad. And yes, I know that it would accrue because if you're not making payments, it's going to push it on out there. But I didn't know if it'd be astronomical. The point being is, let's say you need a 5-year reprieve of making payments, so you would be bettering yourself down the road, in order to make them. It's like pushing the cart down the road before you have to pay the piper, so to speak.
Something that should be noted is if you're not making any payments at all, it is compounded interest. Okay. And so compounded interest works in your best interests when you're savings, or investing. If I put $100,000 in a checking or savings account at 5% per year, I'm getting interest upon my interest. It's compounding on a positive way. With a reverse mortgage, if you never make a payment, you have interest compounding against that same interest. And so it works against you. It's just a small detail that not everybody points out, but I do. I'm very transparent so that someone that chooses to use this program, they need to know the good, the bad, the ugly.
Absolutely. I would wholeheartedly. That's the whole thing on anything. You want to know the good, the bad, the indifferent, and the fine details, because that's where you can get tripped up thinking it's this and finding out that it's something different.
Absolutely.
Once again, thank you for taking the question.
Yes, sir, my pleasure.
I have a question. I'm a little confused about having a line of credit, and the fact that, here's my point of confusion, that if you have a line of credit, as the interest grows, it grows your line of credit or something like that?
It's a very unique set of circumstances for the home equity conversion mortgage compared to a standard HELOC, home equity line of credit. Your standard HELOC works just like a credit card. Okay, so you borrow the money. If you pay it back, then you have more access to just that same money at a later date. The difference, though, is that with a regular HELOC, it can be canceled, reduced, called due and payable. They're always due and payable within 10 years anyways. When the bank needs money, then they're going to ask you to repay them. And so they can call those things due and payable, and they did, many people back in 08 and 09. With the reverse mortgage line of credit, once you establish that line of credit, any monies that are in there grows at the same rate of interest as what is charged on the dollars that you have actually borrowed. So let's say this, you do a reverse mortgage and you establish a $100,000 line of credit. Okay, and let's say the interest rate is 5%. Well, if you do the math, 5% divided by 12 is 0.41666667% per month is interest charged on the money you borrow, but it's also your line of credit is going to grow by 0.41666667%. So each month you'd see your line of credit grow by $416.66. And the next month, that line of credit will grow again, and it's compounded growth. So if you never touch it, you will see that line of credit slowly but surely grow and grow and grow and grow and grow. And so I have customers that want interest rates to go up because they want to see that line of credit grow. And so that's a unique situation. Also, as I said before, the line of credit can never be canceled. It can't be called due and payable. It can't be reduced. Can't be eliminated even if the bank needs money. That's by statute from Congress. And once you close on your reverse mortgage, they can't go back and change the rules later. They can change the rules for future customers that may take one out. But once you've closed it's a contract. And so, we'd have to see the full faith and credit of the United States federal government go away for any of those things to change.
So that kind of, would that kind of go with the first scenario that you said, as far as people that have investments and they don't use the money, but they keep it on a reserve for just in case?
Yeah.
What's the best strategy to use that line of credit?
It's the ultimate rainy day fund. You're exactly right. And so you establish that line of credit, and if you're frugal and you only use it in times of need, it continues to grow and grow and grow. And then when you need it, you can draw it down. And then if you happen to have positive returns, or you come into a windfall or something of that nature, you can pay down what you borrowed, and every dollar goes right back into that line of credit that can be redrawn again at a later date. So anything you pay into it is available for you to redraw at a later date. And the bigger the line of credit is, the more it grows. The higher the interest rate is, the more it grows. So savvy investors have seen to use this, and they set that line of credit up so that if there's an unexpected expense, or if there's something they want to buy and they need money quickly, it's very accessible. It's very liquid. It's just a phone call away to get it. You don't have to worry about making an application to a bank to get a loan if you don't want to liquidate an asset. It's right there. It turns your home equity into a liquid asset. It turns your home into an ATM machine that you can draw from and put money back in when you need it. And it's the only vehicle that does that with all the flexibility that it has.
Mm-hmm. Okay.
Or
Fantastic.
Kelly together. So from a, okay, so if you owned your home free and clear, and then you wanted to, you got one of these reverse mortgages, I guess you're saying they would loan up to 50% if you were, how old did you say again?
So you have to be at least 62, or in the case of a married couple, one of them has to be at least 62. And they'll lend as little as, 50%, as much as 75%, depending upon how old you are. And you can set the reverse mortgage up to receive your funds in one of 4 different ways. You can set up a line of credit, you can do a lump sum, you can do a monthly check, or you can do a combination of those if you qualify for that. Now, part of the qualification process is, do you owe money on your home? But if your home is free and clear and you owe nothing on it, then you can choose between all 4 of those options based upon what your needs are and what you're trying to accomplish with the reverse mortgage. Line of credit, lump sum, monthly check, or a combination of those. And you can change it at a later date without having to refinance if you've made one plan and then later realize, well, I want to do something differently. They charge you $20 to change the plan.
All right, Kelly, what would that do from an asset protection standpoint if someone was coming after you for any reason and they saw that you've got a reverse mortgage? I'm assuming it's going to show up, if you got a $400,000 home, it's going to show up as $200,000, or how much is that deed of trust going to be for?
Brian, does it show up on the registered deeds office how much the mortgage is for?
It'll show, yes, it does. And because all mortgages are public information, as you know.
Yeah.
But like on a credit report, it doesn't show as a debt because there's no payments required. So the credit reporting agencies don't care. But you got to remember, it's just a line of credit. It's not, it's a line of credit based upon an asset. So if somebody was coming to sue you or something like that, they would sue and put a lien on the property. They couldn't force you to take money out of your reverse mortgage to pay it. I guess they could convince you to do so, but they would have to put a lien against your property. But if they did that, it'd be in third lien position, because the reverse mortgage will be in first lien position and FHA will be in second lien position.
And that's probably what you meant, Wendell, right? So that could possibly be a deterrence for someone if they're looking at suing you, if they see that there's a mortgage recorded, that might make it a little bit less likely that, someone would try to go after you because they know that they would be the third in line. Is that kind of what you were thinking with the question?
Yeah, or just looking at how do you make it less of a something they want to come after? Or I guess the other question is, what about how much of a deed of trust do they put against the property? If you could take up to 50%, but then you took a lump sum and that started accruing. I've worked with some real estate and deals where there was reverse mortgages, and it was as much or more than the value of the home. So I don't know, how do they usually calculate that? The
deed of trust is going to be calculated at 150% of whatever the home appraises for. So, and that's based because they don't know how much is going to be owed at the end. And so the deed of trust covers up to 150%. It doesn't mean you have access to that much or that you're going to owe that much, but that's what the deed of trust is issued at.
Okay, wow.
So, if you did a reverse mortgage and you went and took all the cash out, the only way you could keep it away from somebody coming and suing you for it is to stash it in your mattress or give it away to a friend. And, they're still going to find it. They're going to say, what'd you do with all this money? Where is it? And, they're going to come seek it out. Just like there was a law passed not too long ago where people would take out a reverse mortgage and take all the cash out because they knew they were going to a nursing home. They didn't have long-term care. They didn't want to have to pay for that nursing home. They wanted Medicaid to pay for it. And Medicaid used to pay for it. And now Medicaid has a 5-year look back, I believe it is. So that if you were to do a reverse mortgage, cash out, take as much money as you can, and then you say, well, I need to go into this nursing home on Medicaid, Medicaid's going to say, well, what'd you do with all that money? And they're going to go find it. If you gave it to your kids or you stashed it in a mattress, hopefully you took it to Vegas and gambled it all on Black 8, and you could say at least you had some fun with it because they're going to go find it.
Yep. And there's also a law against doing things like that after you've already got a potential liability. So, if you're involved in a lawsuit and then you decide to take out another, a reverse mortgage and get all of that money and encumber the asset, you can get in trouble for, fraudulent transfer of assets. So
yeah, when you take out a reverse mortgage, one of the specific question that the loan officer must ask you is, are you involved in a lawsuit? Do you have any judgments against you? Do you have any federal tax liens against you? And then one of the documents that they have to sign is it's an FBI fraudulent warning saying, do not commit loan fraud. And everything you've told this loan officer is the truth. And if we catch you lying, you could go to jail. And, frankly, seniors, they don't like the prospect of going to jail. So they more oftentimes than not do not lie, and they'll tell you the truth. I'm not saying that it doesn't happen. I mean, I've caught a couple of them telling me a story.
Well, it sounds like to me then, from an asset protection standpoint, let's just say you got a $400,000 property, and you're telling me they're going to come in then, and they're going to put a deed of trust for $600,000, and they're only going to give you a max of $200,000, however you choose to take it, if you even take it. Then you've got a $600,000 deed of trust against a $400,000 piece of property. Is that what I'm understanding?
Yeah, but you don't owe that much. You only owe whatever you borrowed.
I get that. But as far as a creditor or a predator, I call them, coming against you, they're not going to be very apt to want to, if they see that much money owed against a piece of property, then they look at the values of them and, say it's even, it's in that 400 range, they're not going to, there's no meat on that bone in what they're going to see from the public records, I'm assuming.
Yeah, well, but again, if you go and close on your reverse mortgage tomorrow and set up a line of credit, you don't owe 600,000. You don't even owe 400. You don't even owe 200. You're going to owe whatever was borrowed when you set it up.
I get that, but what they're seeing on public record is a deed of trust for $600,000.
Gotcha.
Right?
Mm-hmm.
What do you think, Kelly? If you were going after that, would you see there was any meat on that bone to go after?
So I think that you're giving plaintiffs' attorneys too much credit. I think that if somebody wants to sue and they have any sort of basis in a lawsuit, we will do asset searches before filing lawsuits, but judgments can also last for 20 years. And so, you get a judgment and it's a lien on property, and for all we know, we might be first priority on a lien down the road. And there's other assets to attach to as well. We might uncover some other property that you've got in another state that we can attach to. So I don't know that finding a deed of trust on a piece of property is going to deter someone from filing a lawsuit and trying to get a judgment against you. I think that most people, and what if there's insurance? Woo! Then we're going to go after and we're going to try to get insurance. We don't even care about your property if the insurance company pays the claim. So I don't know that is a good vehicle to make you less likely to be sued.
And again, if you file that lien, you'll be in third lien position.
So
Yeah.
how does that play out? So you're saying the FHA is part of this reverse mortgage?
Yeah, so FHA is the guarantor of the loan. And so in order for them to be that guarantor and to step in case the lender defaults or the lender goes away, they file a second lien position. So the lender is in first lien position and FHA is in second. That's why, you typically never see somebody get a second mortgage or a home equity line behind the reverse mortgage because almost no lender is willing to go into third lien position.
So there's no percentage of either one of them. I guess it's just all undivided interest or something, the way that's set up.
I guess so. I'm not, I'd have to defer to Kelly. I'm not the attorney on the call today.
So I think, but I'm not certain, that inferior liens can force sales, but they oftentimes don't because they're not going to ever get any money out of it because there are superior liens. And so if I were to do discovery and find out that you did not in fact owe $200,000 on that property, then I might actually try to foreclose that lien because then I might get paid because you don't owe Mutual of Omaha $200,000. And I can find that out by serving you with interrogatories. So that's what I think. I do, more on the transactional side, kind of proactive stuff, and less on the litigation. That's my husband. I try to stay out of the courtroom now. I'm getting too old for that. But I think that's the answer. So, I mean, to summarize this, I don't know that any of this is going to prevent you from getting sued.
No, I'm not saying it is. I was just looking at it as a vehicle that might be a deterrent. I wouldn't say I agree with you. It's not a total thing. I was trying to look at all the pros and cons of it and what was the advantages or disadvantages. So.
I mean, it definitely, having that show up, could absolutely deter people. I mean, a lot of people aren't going to know what they're looking at. So, to your point earlier about seeing that $600,000 mortgage on there, going, ooh, well, I'm third in line. I'm not getting any money. There's some merit to that. But I do also know that we have a lot of other things at our disposal. So we'll try to find assets other ways.
Okay. Good. Thank you.
Mm-hmm.
Okay.
I got another question or two, but I won't take up the floor. Somebody else may have a question. I'm gonna hush for a minute. So.
Well, you're asking good questions, Wendell, so go ahead. And technically we're supposed to end at 9, but if people have more time, we won't get kicked off.
All right. Well, until somebody else goes, I'm gonna throw another one out here. So I have looked at I'm not sure what the right term is for it, but I think one of it is called a spendthrift trust. One of it's maybe another term is called a dynasty trust type setup. Are you familiar with those?
Yes. Yeah. So
can you tell us a little bit about what they are, what they do? Do you do those?
Yeah. So oftentimes a spendthrift trust is going to be incorporated into other trust. So if you've got just your standard vanilla revocable living trust, a lot of times we'll put spendthrift provisions in the revocable trust. They're almost always going to be in a dynasty trust. After I explain what that is, you'll understand why. So the spendthrift provisions is language that tells the trustee that if the beneficiary has creditors, the trustee is not to distribute money to the beneficiary. Now, this does not work for you. So this is not something that you would set up to protect your money from your creditors. This is something that you would set up to protect the money that you leave to your family from their creditors. And a lot of times you see this for parents who are worried about their children getting divorced and having the ex-spouse take half of their property. You also see it just for other creditors, gambling debts. We can also put language in a spendthrift trust that says that if the trustee thinks that the beneficiary has a substance abuse problem, the trustee is not to distribute any money to the beneficiary, because as long as the money is in the trust, it's creditor proof. But as soon as it gets out and into the beneficiary's hands, the creditors can get it. And then there's also this middle ground that says that if the language of the trust directs the trustee to make a payment, that money is also susceptible to creditors. So if I've got a language in a trust that says once a year the trustee is to distribute $10,000 to Jane, then a creditor can attach to that $10,000 every year because it is a required distribution. But if I include spendthrift language in the trust that says, however, if the trustee thinks that the $10,000 is going to go to a creditor, the trustee has discretion not to make that payment. The trustee doesn't have to make it. And what you hope with that is that eventually down the road, the creditor won't exist anymore. The divorce will be done. The substance abuse problem will be resolved. And then later down the road, the trustee can still distribute that money to the beneficiary. So that's what spendthrift language is. We typically don't do like a standalone spendthrift trust. We might include a subtrust in a bigger trust, or we might just include language. So I'll typically say like spendthrift language in a trust. So that's what that is. The dynasty trust is really nothing terribly special other than it's set up to pass on property generations in the future and pay as little estate tax as possible. In North Carolina, that's not a huge problem for most people because North Carolina doesn't have an estate tax. And let me just back up and say, I'm licensed in North Carolina and not South Carolina. So if there's anybody on here from South Carolina, sorry. South Carolina doesn't have an estate tax either. But so North Carolina doesn't have an estate tax. So all we have to do is worry about the federal estate tax right now. There is an exemption of $11.7 million a person. So I can die with $11 million and my estate does not owe any tax. And if I'm married, I get to double that. So it is $23.4 million for a couple. And the reason why we include it as a couple is because, let's say I've got $5 million and I die, my spouse can take that unused exemption and add it to his. So you always look at it as a couple. So for most people in North Carolina, you're not going to utilize these dynasty trusts because you aren't paying any estate tax. Your estate isn't large enough. But if you're lucky enough to have over $20 million in your estate, then what you want to do is try to pass that on to people without paying estate tax. And so you can set up ways to gift property. You can gift certain amounts of property every year to numerous people without paying any gift tax or without filing a gift tax return. And so it's just a way to pass that on in the future to other generations, paying as little tax as possible. And it keeps it in the trust. A lot of trust will say, this property shall stay in trust until my son is 35 and then he gets it. Well, and outright in the trust terminates. A dynasty trust is not going to terminate. It's just going to keep going and going and going on into the future for grandchildren and great grandchildren and all that.
Hey, I got a quick little thing to add to that. I helped a customer in Florida who had an estate that was worth more than the estate tax. And he did a jumbo reverse mortgage on his primary residence, which was multi-million dollar home. He took out that cash and donated it to charities and family members and things like that, thereby reducing the size of his estate to such a point where he did not have to suffer that estate tax, what is it, 40% these days?
Yeah, it's actually higher than that, because
Yeah.
the bracket is 40, but then there's all of this other like investment tax and all this other kind of stuff. So
Yeah.
they hit you really hard.
Yeah, he had a $10 million home and he took out $5 million on a reverse mortgage that he was then able to donate to charities while he was still alive. So he could go there and hand them the check in person. And so that was $5 million of estate that wasn't taxed at 40%. You can do the math.
Mhm. Yeah. I've also heard of people taking reverse mortgage money and using it to buy life insurance, and then putting the life insurance in an irrevocable life insurance trust and getting that out of the estate. And then when that person dies, that money doesn't count towards their estate. And if there's any estate tax that is owed, the family can use the money from the life insurance policy to pay the estate tax. Because if you think about it, I know that there's plenty of multimillionaires, but if you run into an average Joe who's got a $30 million estate, it's because they own a business or they own a lot of real estate or something like that. And the IRS, when you pay that tax bill, they want you to pay in cash. And so, if you have to start selling assets, technically it's an estate tax. Your estate owes it, not the beneficiaries, but the beneficiaries don't get the property until the estate tax is owed. So in reality, what it looks like is your kids are having to sell the property that they've inherited to pay tax. That's one thing that I have heard is people using the money to buy life insurance. Now there's some rules with it. You have to survive long enough so that it's not counted. So there, with all of this stuff, there's tons of rules because people will, find ways around it. And I think it's 3 years. You have to live 3 years after, buying a life insurance policy and putting it in one of these trusts. But anyway, that was a long-winded answer, Wendell.
Well, that's good.
Your trust questions.
Yeah, that's very good.
Oh, good. Thank you.
Is that the same in order to protect the family where the assets pass down the line? In North Carolina, do they do per stirpes?
The default is per stirpe. So if you die without a will or without a trust, that is the default. But if you have a legal document that leaves property to heirs, you can put whatever you want to in there.
So if a child may marry or may be married to somebody that the family is not too sure of, then the owner of the property, when they do their trust, they can do it per stirpes in North Carolina, where it will just pass down the bloodline and that spouse won't get anything.
Yeah, and like I said, that's default too. In North Carolina, if you have a child that predeceases you, their share is not going to their spouse. Okay. Now it would go to their kids. So what per stirpes means and what per capita means is per stirpes means that if that kid that died had 3 kids, their 3 kids would split that one share. What per capita means is you look at who's out there when someone dies, grandchildren and children, and add that all up and split it up. So you can see most people want to do the per stirpes because it's fairer. Why have a child get the same amount as the grandchildren? So that's what per stirpes means. So the only way that you're going to end up in a situation where a spouse might get something is if there's a simultaneous death situation. I mean, unless someone leaves the spouse something, but let's say, you know, there's a family trip and a parent and a child die at the same time. Child's estate plan has everything going to spouse. Sometimes then what that means is the deceased person, it goes to this deceased person, and then it goes to spouse. So that's something else that we can do, is we can plan around that. So sometimes I'll write into my legal documents that someone has to survive by 30 days or 60 days or 90 days. And the idea behind that is so that if this person dies 30 days later, they don't get that share. It skips them and does whatever, you know, they had put in there, which oftentimes means going to grandchildren and not the spouse. So, so yeah, that's the way we get kind of around that.
Good. Because my estate plan was, and my parents' estate plan was done in Illinois. And so I guess that's why they had to make it per stirpes, because of the law of Illinois. So
yeah, and every state has different laws. Illinois has an estate tax, and the exemption is low. I think it's like $4 million. And if you own property in other states with an estate tax, but you live in North Carolina, you probably still have to pay estate tax because you own property there. Now there's ways around it. One of the ways we get around that is by utilizing LLCs, which is one of the things that I was going to talk about tonight. If we have a North Carolina LLC and you own real estate in Illinois and put it in the LLC, we can make an argument that you don't own any Illinois property because the property is North Carolina LLC, and try to get away with you not having to pay any estate tax. You know, that we did that with a client before. I consulted with an attorney in Illinois about it and brainstormed, and we came to the conclusion that that was an acceptable practice up there. So that's what we've done for them down here. So, you know, I'm not licensed in Illinois, so I can't make that call, but whenever I have a situation like that, I'll find someone to co-counsel with in that state, and we'll try to hatch a plan because nobody wants to pay tax. But anyway, so that's one thing that we can do. An LLC is personal property. Real estate is real property. So one way to convert real property to personal property is by having the LLC own real estate. Suddenly you're not, you know, owning real estate in Illinois. You own a North Carolina LLC that owns real estate in Illinois, and LLCs don't have to pay estate tax.
excellent.
So yeah, I mean, people who own property in multiple states really need to utilize working with an attorney, not just for the LLC, you know, the asset protection, but also for estate planning. If you own real estate in multiple states, when you die, your family, your executor, has to administer your estate in every state where you own real estate.
Absolutely.
And that can be expensive, and it can be a big headache for them. They're probably going to have to hire an attorney in each one of those states.
Yep.
If you instead utilize a revocable living trust and move your properties into your trust before you pass away, when you die, if all of your properties are housed in the revocable living trust, your executor only has to administer your estate in North Carolina, and they may not have to go through probate at all. They may just handle the trust privately without going to the court system. So that's something else that's really important for people who own property in multiple states.
Very much so. Very much so. Oh. I know we've just had such a wealth of questions, and we do have time to hear what you have to contribute to us, Kelly, because you're a big part of this as well.
Well, so I knew that I was going to talk to a bunch of real estate investors tonight, and so I just wanted to hit the highlights with utilizing the LLCs and the revocable trust or trust in general for estate planning and asset protection. The first thing is LLCs. If you own, there are other types of businesses that you can utilize for asset protection: a corporation, a limited liability, limited partnership, and an LLC. All of them have the liability protection, but they also have other formalities and tax things that make them less attractive. So most of my clients who utilize a business entity for holding real estate is going to do it in an LLC. So that's just a little kind of caveat before I dive into the LLC. That's why I'm only talking about an LLC, because it's the best way to do it. So an LLC is really inexpensive to form, $127 at the Secretary of State's office. You get a tax ID number, open a bank account, separate your business and your personal expenses, file your annual report every year, and you're good to go. If you do not separate your business and your personal expenses and actually treat your LLC like a business, if you do not file your annual report every year, if you are sued and you want to lien on that LLC for asset protection, you may not get it, because a plaintiff is going to say, well, it was a sham LLC. You know, she was just using it for, you know, these purposes and wasn't really running it as a real business. So we're going to see through her, and or see through the LLC, and we're going to go after her. So just doing the LLC is not enough. You really do have to treat it like a business. And real estate investing is a business. So having that in place is the biggest thing. You can own multiple properties in the same LLC. If you are sued for something, then a creditor could come after all of the properties that are in the LLC. So I have a client who probably owns about 500 pieces of property, and they have, without any sort of rhyme or reason, you know, created about 15 different LLCs, and they'll put, you know, 20 properties in each and try to spread it out. With that comes more expense. You know, every year you've got to file that annual report, you've got to do taxes. So, you know, if you have 5 rental properties, maybe you don't want 5 LLCs. If you have 500, maybe you do. So there's a balance there, you know, with the expense versus, you know, the risk exposure. The other good thing about having properties in an LLC is that they're protected from your personal creditors. And this is something that a lot of people forget about. But if I'm in a car accident and it's my fault and I really hurt someone and they come after me for, you know, hundreds of thousands of dollars, but I've got rental properties in an LLC, those are safe from my personal creditors. So that's something else that shouldn't be overlooked, is the asset protection works both ways. Let's see. So I prepared notes, so forgive me while I'm looking at all of this. A lot of people say, well, I've got insurance, so I'm not worried about asset protection. That's the wrong way to look at it. Insurance may not cover what the claim is. And so it's definitely good to have there as added protection, but it's not in lieu of formalizing a business to hold these assets. Let's see. If you have an LLC with more than one person, you need an operating agreement. The statute in North Carolina requires it. So if you don't have one and you're sued, that's one of the factors that they could look at to see if it's a sham LLC or not. So you need to have something in place just to cover you in that way. Anyone who's tried to purchase property using a lender and putting it under your LLC has probably been asked before, well, do you have an operating agreement? And you've probably had to produce that. So we get a lot of calls from people who kind of set stuff up themselves, and then they get to ask that question, and then they call us and we have to do, you know, an operating agreement for them.
I have a question with that, Kelly. You say if a person has more than one person in the LLC, so if they have a member or
Mhm.
two members and a manager, they need a operating agreement.
Yeah, if they have more than one member.
Okay.
Yeah. I mean, and just, practicality purposes, you need one, because you need to know how you're splitting profits and who's doing what and all that good stuff. But legally, the Limited Liability Company Act in North Carolina says you shall have an operating agreement if there's two or more. So just, to comply with what the law is, to get that liability protection, you really need an operating agreement.
Thank you.
So now I'm going to talk about what happens to your LLC when you want to retire or pass it on to someone else, and then I'll talk about what happens when you pass away. So if you just own real estate in your own name, when you decide that you want to retire, from the real estate investing business, there's no business there, right? So you're still obligated for any debt that you might have on any of these properties. So it's, a personal debt. If you wanted to gift a property to a child, you're still obligated on the loan. So the only way that you're going to get rid of the loan is if the lender allows you to transfer it, or if you sell it and then it's paid off as part of that process. If you own a business, if you own an LLC that owns real estate, you can gift the LLC and include the debts with it. So that's another vehicle. And when we're talking about retiring, it's a lot of people, you work hard to get this, and then you kind of get to this point and you're like, well, what do I do? Either hold on to it and then you die, or, is there a way that I can, start selling some of this for money for me to live off of, as I get older. So you have a little bit more flexibility with an LLC. You can sell parts of the interest for the LLC and not just parcels of property. So you could decide to, sell or gift 25% of an LLC to a family member versus, well, I've got these two houses here, do you want them? So it's looking at it in terms of the LLC being, this own separate entity. So when you die, kind of the same thing. So if you pass away and you own real estate, it has to go through probate, and it's not in a trust. So we're going to talk about trust in a second. If you die and you own real estate and it's just in your name, it has to go through probate before it gets to the next person, whoever you want to leave it to, whether that's your heirs at law or your heirs that you've got listed in a will. And if there's any debts in your estate, then they need to get paid first before your property goes to the next person. So that's just kind of a, very, very general, this is what happens with real estate. Same thing with an LLC, except that you can have an operating agreement that has other language in it. So if the operating agreement says, well, when one person dies, the other member gets the first right to buy the other person's interest out, the other owner can continue to own the LLC with all the real estate assets in it, as long as they pay the estate the money. So there's a little bit less disruption there if there's an LLC versus if the property is just in your name. You know, what normally ends up happening, I think Brien mentioned this before, like kids inherit property and they just sell it and split the proceeds between between everybody. You know, like there a lot of times, you know, nowadays, you know, kids are living in different states. They don't want you know, to deal with rental properties or things like that. So they'll end up selling the properties. So anyway, that's what happens when you have real estate in your name when you pass away. If you own it with someone, might be different. If you own real estate with someone and it's joint with rights of survivorship, they'll automatically inherit it. If you own property as husband and wife, they'll automatically inherit it if you've got a surviving spouse. So it doesn't always have to go through probate and be subject to creditors, but sometimes it does. So if you're not going to own real estate in an LLC, the second best way to own it is, for asset protection purposes, is as husband and wife, or husband and husband, or wife and wife as spouses. And that is because if just to go back to my example with, you know, me getting in a car accident, if I got into a car accident, I was held responsible and owed, you know, several $100,000. They would not be able to file a lien on my real estate if I owned it as spouses. So that's the second best way to do it. Now, that's not the best way for total asset protection, because that creditor is going to come after everything else you own. So it is better to, you know, have things put in LLCs and hope that it protects you completely. But if you're not wanting, you know, if you're a new real estate investor and you're not wanting to bite the bullet and just do an LLC, owning property as husband and wife is the next best thing that you can do. Now, it's not perfect. If one spouse dies, a lien can attach once there's only one owner of the property. So without a will, the laws of the state of North Carolina are going to determine who gets your property. So when we're talking about estate planning, like at a minimum, you know, LLCs, real estate aside, like we don't just need a will, but at a minimum, you need a will, because there can be some unintended consequences without it. Half relatives inherit. So you might have a half sibling or something like that you didn't even know about inherit part of your estate. Step people do not. So maybe you've got a step sibling who is so close to you and you treat them like they're your blood sibling. They're not going to inherit under the law, because they're just a step person. A lot of people are surprised to learn that spouses do not automatically inherit everything. They inherit a percentage. Now, most of the time they do end up inheriting everything because they're joint on stuff. But what the law says is they only get a certain amount. And so sometimes spouses and children end up inheriting estates when the person dies without a will. So just, I mean, at a minimum, get a will done. For real estate investors, a will is not going to be sufficient if you have a lot of property. You really need to utilize a revocable trust if you are putting your properties in LLCs. The reason why is, remember I said earlier that your real estate, when you put it in an LLC, the LLC is personal property. Well, guess what? Personal property goes through probate. So there's the downside. So the benefit of putting your properties in an LLC is liability protection. The downside is when you die, that has to be probated. So you own an LLC and it has 5 pieces of property in it and it's worth $1.5 million. You've got $1.5 million worth of property going through probate. The court determines its fees based on the amount of property that goes through probate. It's 40 cents for every $100, and it's capped at $6,000.
Mm.
Okay, so you could potentially have $6,000 in fees coming out of your estate. So for people who do want to utilize the LLCs for asset protection, you also really need to utilize the revocable living trust as well. It's really, really easy. Instead of us retitling all of these deeds and all of these houses to your trust, we just do a really simple assignment document that assigns your LLC to the trust, and that's it. So some of my clients will have several different properties and they won't have an LLC. In order to put them in the trust, we've got to do new deeds for all of them. But if you had the LLC, like I said, it's just one piece of paper, easy to move that over to the trust. Then when you pass away, your executor doesn't have to file anything with the court. That's just a real easy explanation for that. When someone dies and the court says, give me a list of all the property they had in their name at the time of their death. And that's what you file with the court. If I have a trust and I have retitled my assets, so they're no longer in my name and they're in the name of the trustee of my trust, when the court says, Kelly, give me a list of all of Brian's assets that he had in his name at the time of his death, I'll say, court, there's nothing to list, because there's nothing in his name. And that's the way that it works. So the trust is not this magic document that, boom, no more probate. The way that it works is the retitling. And so that's why it's really unfortunate. Sometimes older people will go to these seminars and they'll be sold these trusts, and they'll pay $5,000 for a trust, and then they leave and they've got the trust and they never do anything with it, and then they pass away and their family has to go through probate. So when we work with our clients, we charge them for what we do, but we're also doing the full thing. So we are working with them to make sure all of their assets are moved over to the trust, because what's the point in having it if it's not going to work the way that it's supposed to? So that's kind of the yay, I own a lot of property, so now I need this LLC, which now means that I got to get the revocable trust. But also, buying real estate is the best thing that you can do to increase your wealth. So unfortunately, with that comes some added expense with the estate planning too. But that's really the best way to deal with both asset protection in North Carolina, use the LLC, and then estate planning, use the revocable living trust to get your assets to who they're supposed to go to.
Kelly, so even if a person has their main house in another state, let's say Maryland, but they own property in North Carolina, then the North Carolina, if you were the North Carolina attorney, would coordinate with the Maryland attorney to make sure that things are set up properly. So should somebody get hit by a bus, God forbid, or something, things will pass and be in order in the way that they wanted them to be.
Yeah. So whenever I have a client who hires me to do a revocable trust or estate planning, and I find out that they have property in another state, I track down an attorney in that state and coordinate with them. And of course, my client has to pay them for the work that they're doing. It's not free, but I do, find these people for them. And I can tell you that some attorneys don't do that. Some attorneys will say, okay, here's your homework. You need to find an attorney in Maryland to do this. And 9 times out of 10, the client's not going to do it. Right. So we try to make sure that we, we're not going to force you to hire someone, but we're going to find someone for you and put it in front of you to make it as easy as possible. Because it happens all the time. I am hired all the time by families to just probate their mountain house or their beach house because they forgot to put that in the trust, and they have this expensive trust package from this other state, but they didn't put their North Carolina property in there.
Absolutely.
And it's not the end of the world. It's not costing thousands and thousands of dollars to do it, but it's just, when a family member dies, you're grieving. The last thing you want to do is start tracking down multiple attorneys in multiple states to handle stuff, especially if your family members have spent money on an estate plan.
Right.
You want it to be as easy as possible, so that you don't have all this work to do when you're grieving the loss of a family member. So we just try to make it as easy as possible for people. And yeah, having property in multiple states is definitely one reason why you need to get a trust.
Mhm. Yes, we lived through that. We had my parents, and we had an estate attorney and estate plan and trust, and it wasn't anything in the trust. So yeah, it was a mess. Yeah. Let me see. I'm gonna save that for that question for another time. It was about short sales and selling. If there's a short sale, and I'm gonna not even go into that right now. Yeah, no, we won't go.
Thanks for the education on trust, Kelly. That was very informative.
Yeah. I had some notes in here to talk about spendthrift trust, so Wendell beat me to it. But yeah, I mean, for asset protection, there's kind of two different things. There's one, asset protection for your stuff while you're alive, and then also protecting your assets for your family in the future. So there's only so much you can do while you're alive to protect your assets. But I'll just mention, for your for protecting from your creditors, life insurance and retirement is protected. So if I'm contributing lots of money to my retirement account and I have a life insurance policy and I get in a lot of trouble and I get my pantsuit off, they can't come after my retirement and my life insurance. And that's great because those are assets that you leave to your family. They're also protected in your estate too. So if I die and I have $1 million in credit card debt, they're not coming after that retirement and that life insurance. Now, once it gets to your kids, it's up for grabs for their creditors. And that's when you would utilize the spendthrift trust that Wendell was talking about, if you were worried about something like that happening. But yeah, life insurance and retirement is a great way to protect assets from your creditors.
Excellent. Oh, there's when we were talking about selling the LLC or making a gift with the LLC with debt. This might be more for a real estate attorney. Do you do real estate law as well?
No, we just do deeds when we're transferring them to LLCs or trusts for our clients. Yeah. So if that question was about a 1031 exchange, I can't answer it.
Yes. No, am answering a question from the iPhone. Yes, you can ask questions. Anybody can ask questions. Are you done with your presentation, Kelly?
Yeah.
Okay.
I'm free to answer. Yeah.
Yeah.
Hi, Miss Kelly. My name is Jasmina, and I came in late into the section tonight, but I heard half of your conversation talking about the trust. One of the questions I have is, can I put a property under a trust if I still have a loan in this property? My broker said that if I do that, the bank, the lender can call that note due if they find out, if they can see that, I'm trying to put that property on a trust.
It depends on the trust. But generally the answer is yes. There's a federal law called the so there's a liquor called like Saint Germain or something like that. So I always mess it up, but it's the Saint Garn Germain Act or something like that. I'll look it up. But anyway, it says that you can transfer property to your trust without the lender calling the loan. But it's not just that simple. There's some other stuff in there too. So so the answer is depends. But I have clients who transfer property to trust all the time, and there's no problem with it. Because when you transfer your property to a revocable living trust, it's still your property. The title changes, but it's still your property. You can sell it, you can give it away, you can take it in and out of the trust, you can do whatever you want to with it. You're still obligated under the mortgage for that debt. So that's why it's okay to transfer it. Now, if you transferred it to some other trust where you lost possession and control of the property, that might be a different story. Because then the property may not belong to you anymore, but you're still on this loan. They may call the loan then. But if it is a revocable living trust, which is what I typically draft for my clients when we're doing estate planning, you can absolutely transfer that to your trust with a mortgage.
We do it all the time. It has to be a revocable trust. It can't be an irrevocable trust. And all we do is we ask that you send us a copy of that trust document. We forward it to our attorneys, and I've never seen one turned down if it's a revocable trust.
Okay, great.
And if it's an irrevocable trust, you probably don't want to transfer it there because you lose control of the property. People utilize irrevocable trusts to get property out of their estate for reasons like estate tax, like Medicaid planning, stuff like that. So if it's property that you want to continue to use and enjoy and all that, then it's probably going into a revocable trust.
Okay, great. Okay, thank you.
You're welcome.
I one more question. Adina, are you going to share her information, or are you going to email us her information?
Yeah, I was just going to suggest for Brien and Kelly, if you guys put your information, your contact information in the chat,
Okay.
and I will save the chat, and hopefully we'll be able to share this recording with the chat. And if not, we will have to do this over again because this was valuable information. But yeah, your
I accidentally hit enter before I finished typing everything in. So you got me in there twice. Once this was the same. Thank you so much for giving me an opportunity, Adamma. I really appreciate it. Would love to be invited back if I could ever be of assistance in the future.
Yes, and we appreciate your input, Brien. It was fantastic. And Kelly as well. I have a very expensive coach that is working with me, and she gave me an assignment because the one that we did last month was so powerful. She gave me an assignment to redo or have a part 2 and have different presenters. And I think I did a good job in finding you guys. And
yeah, well, I had a great time. I love talking about this stuff, and I can tell that Brien's super passionate about what he does as well. Just real quick, I looked up the law. It's the Garn Saint Germain Act. So not to be confused with Saint Germain or whatever it's called, which is the liquor. And it is 72 is the new age for the required minimum distributions. So I was right about that, but the days where I have everything memorized are long gone.
Yes. And does anyone else have questions? We do have time.
I have one more question of Brien.
Mm-hmm.
if you're trying to use a reverse mortgage because you're old enough that you couldn't get the long-term care insurance without it costing a lot, is that an instrument that people are using? And if so, how does it work?
A little bit. It's not widely used for that method, and I don't see it used as a way to fund the long-term care insurance policy from an insurance carrier. What I've seen is people do what we call self-insure by leveraging the home equity, setting up a reverse mortgage line of credit, and then if they ever need that in-home care, they use the reverse mortgage to pay for it. It's important to know, though, if you take out a reverse mortgage and you leave the property, you must return within 12 months, otherwise the loan becomes due and payable. So if you think you're going to be leaving that property and go into an assisted living facility or assisted care facility for longer than 12 months, just know that after 12 months, that loan will be called due and payable, and it'll have to be repaid somehow, either by sale of the property or something of that nature. So if it's a long-term care policy that you think you're going to want to use to stay home, then I would say it's a great self-insurance vehicle that you would not need to spend the money to buy the policy. You would just use those proceeds to pay for your care. Does that make sense?
Well, in a way, maybe I'm misunderstanding. I talked to AIG once, and I was under the impression that you could take that out, use it to supplement or pay for your assisted living. You weren't doing hospice or anything at home, and that your wife couldn't be forced out, even though maybe you were upside down in the house, as long as she was living and met the criteria of keeping the taxes, keeping the homeowners, and keeping it in livable condition. That's what I was understanding it to be, but that's not the case.
No, that is the case. It's as long as one of the two people continue to live there as the primary residence, then the loan is not due and payable.
Okay. Well, the way you was explaining it at first is like if I went in, but again, I didn't make it clear that the wife was still there.
Yeah, the loan is only called due and payable when all borrowers have permanently moved out, sold, or died.
Okay. At that particular point, it's like if you weren't going to leave it to an heir, it doesn't matter. It just kind of goes away. And from that standpoint, correct?
Sure.
Okay. All right. That answers my question. And I was correct. I just wasn't hearing that when you first explained it. I was thinking that if I had to go in, then she would be forced out, but that's not.
Yeah, they can't force her out, and it's not due and payable until such time as you're both gone permanently.
Right.
You can leave and go into an assisted care facility for a short period of time, up to 11 months and 30 days.
How about if you have like not a retirement home, but other properties that you'd like to go and visit? How long can you stay there, beach house or mountain house?
As long as you come back within 12 months for a day, you're
okay.
all right.
Same thing then. Okay, very good. That's all. Thank you very much.
I guess that's also intergenerational, creating intergenerational wealth too, because if you have an older parent and an adult child, or that if you bought it together, parent or grandparent and child, or parent and child, if they're both on the loan, then if mom passes away and son still lives in the house, then that loan is not called due. Is that right?
No, that's not true. And
that's right.
It's because it's mother and son, or it only works that way if they're a married couple.
You did say that.
Or it wouldn't work that way if it was, you wouldn't have that same protection. It's only protected when it's a spouse.
Yeah, you did say that. I forgot about that. Excellent. Great.
And as far as I know, that includes, non-traditional spouses, if I'm saying that the proper way.
Mm-hmm.
Or
there's a federal law that requires that now. So yeah.
So yeah, it can be, same-sex marriage. It works just fine.
Good. Excellent. Okay.
Well, my college age daughter is home for just a couple of minutes, so I got to run.
Okay,
I haven't seen her in a couple of weeks.
okay,
Yeah,
appreciate it.
thank you so much again for allowing me to come. I really appreciate the opportunity. Kelly, I really learned a lot tonight. Thank you for your contribution.
Yeah, it was nice to meet you.
Nice to meet you too.
Yeah, very, very good. Very
Thank
good.
you again.
Thank you.
All right. Thank you.
All right.
Thanks for having me. It was nice to meet everybody.
Nice to meet everybody as well. I mean, nice to hear from everybody, and the questions were really, really awesome. I didn't know if anyone else had a question or two before we wrap up.
Adamma, I just like to see if I can get their information on the on an email or whatever, however you guys are going to share it.
Yes. I think all I have to do is save the chat. Let's see more.
Or is it in the chat?
Yeah.
Okay, great. I can just I can get it from here. Perfect.
Okay. Does anybody know how I did do this before? Uh-oh. I did do this before.
There's three little dots at the bottom of the chat screen next to file, and if you click on that, it says save chat.
Let's see. Chat. Okay. Let's see, to everyone in the waiting room, type message here. No, that's not it. The three little dots. Ah, save chat. Got it. Oh, yes, yes. And I guess let me see, type message here. Adamma, someone wants my contact information as well. ADAMMA MALIK 704-486-9980. Okay, and it's Concord subgroup. State Investment Association at Gmail. All right, everybody. If no one else has any other questions.
Adamma, hey, it's Melissa. I actually have one for Kelly.
Okay.
Kelly, regarding what you had said about suppose that someone had done all their homework, they consulted with you, moved all their properties into their all LLCs and put it in a revocable trust. Then for whatever reason, the person becomes in a state that long-term skilled care is necessary. They haven't provided for it by any other means. And unfortunately, when the cost is calculated, cost of care is calculated, it's determining that Medicaid might be the best option. So would that funding of the irrevocable trust and placement of the properties in there be subject to the 5-year look back?
Yeah. So, well, first of all, moving the property to the revocable trust does not get it out of your estate for Medicaid purposes. So
Okay.
regardless of the 5-year look back, whether you did it 15 years ago or 2 years ago, Medicaid's going to look at it to figure out how much property you have.
Okay.
So, if I've got 10 rental properties and 2 LLCs and they're in my revocable trust, I probably don't qualify for Medicaid. And so if you had someone like that, you're going to start selling properties to pay for long-term care, or you're going to work with a Medicaid planning attorney. I am not one. More than 5 years before they need the skilled care,
Right.
and start getting rid of that property. So, and that's the whole kind of problem with this 5-year period now is, who knows that they're going to need it 5 years before they need it. But so anyway, so some people do start getting rid of property. And it's a conversation to be had. If you've got that property, do you buy long-term care insurance with it instead?
Right.
Because I would rather be in a facility with paid for by long-term care insurance than Medicaid.
Absolutely.
So yeah. But to summarize, a revocable living trust is not used to avoid creditors or to qualify for Medicaid.
Okay. I thought that was the case, but I want to make sure. Thank you so much.
Yep, you're right.
What about an irrevocable trust?
Yes. Now that would be subject to the 5-year look back. So you would need to move the property prior to the 5 years. But you know how I said that when you move it over to the irrevocable trust, it's not yours anymore. You lose control over it. So that is a way to get property out. And instead of you just gifting property to people, willy-nilly, you can put it in a trust and control what happens to it by the terms of the trust, but it's not going to be your property anymore. So you do want to wait to do something like that until you know that that's what you need to do.
So you said even if it's in a revocable trust, that does not preclude the 5-year look back.
Yeah, a revocable trust, it's your assets. An irrevocable trust, it's not your assets. But if you got to qualify for Medicaid and you transferred a lot of stuff to an irrevocable trust within the past 5 years, Medicaid will count it.
Okay. So it
Just
still
like
has to be beyond 5 years. Okay.
Because people transfer their property to have the government pay for their health care. And we're all funding that when we pay our taxes. So that's what they're trying to do, is to make sure that people aren't doing that for the purpose of doing that. But they've made it hard. But there's other things that you can do. There are attorneys who specifically do Medicaid planning, and that's what they do is they set up trust and retitle property and make sure that it's in someone else's name, but the person still kind of has the benefit of it in legal ways. And I don't do that. It is highly specialized. The laws change all the time. It's different even by county in North Carolina.
Oh, wow.
So because the counties are the ones who distribute the Medicaid and stuff like that. So anyway, so I don't do it. So if I ever have someone who comes to me who wants that kind of planning, I always refer it out. But that's about the extent of my knowledge, is what trusts count for what in the 5 years and all of that good stuff.
Okay, and LLC is still.
No, yeah, an LLC is your personal property, so it's going to count. And
I will get that referral from you, because as we're going along and we're seeing for different audiences that are on different levels, we need a team to get to get everybody ready and fully prepared. And I just appreciate you so much, Kelly.
Oh, you're so welcome. Thanks for having me.
Thank you. So if no one else has any other questions? No? All right, then. I've got the chat saved and I have the recording going on. Okay, so I want to stop the recording. Let's see. Stop recording. Got it.